Okay. So would you like Mr. Nupo to address me, or would you like to respond?
To address you, my lady, I think.
He should address me. Okay. Mr. Nupo.
Thank you, my lady.
Okay, I'm simply permitting this address because no heads have been filed in respect of that application, right? For the benefit of the SIU, I think it's fair to them.
My lady, may I bear with me? I just want to get my papers, the relevant pages. Thank you, my lady. My lady, we have specified which aspects of the answering affidavit of the SIU in the interlocutory application are to be struck out. We set out the grounds in our application. And the first aspect that we seek be struck out is in respect of paragraph 14 of the SIU's answering affidavit. And in that regard, a specific part of it. If one has a look at paragraph 14, and in the third line, after the comma, the words that commence, or the portion that commences the words, and the 12th respondent's attorneys, all the way to is not warranted, is sought to be struck out. The grounds of the striking out sought is that those allegations are unfounded, it's defamatory and irrelevant. The 12th respondent will be prejudiced if that aspect is not struck out, as the content seeks to color the tribunal's mind on the aforesaid allegation and influence it in determining the application against him. My lady, with your leave, I'll deal with the relevant cases at the end of this address. The next specific aspect that we've dealt with to be struck out in the answering affidavit of the SIU is in respect of paragraphs 16, 17, and 18. And we seek the entire contents of those paragraphs to be struck out. The grounds are that the content is inadmissible. What is contained therein, my lady, are exchanges between the parties in negotiations to attempt a settlement that is not reached. Some of the exchanges there are even marked without prejudice, and these are inadmissible with respect. And if they are not struck out, the applicant again will be prejudiced by the contents remaining and is designed to try and influence the tribunal's decision against it. My lady, additionally, there's an attachment referred to in paragraph 18 of the SIU's answering affidavit. In paragraph 18, reference is made to an annexure SM5. But when one has regard to that annexure, it is exactly the same document as annexure SM4. So the further ground in the alternative is that annexure SM5 should be struck out as it is unnecessarily repetitive, and prolix. And the applicant, the 12th respondent, is going to be mounted unnecessary costs if that is not struck out. The next aspect, my lady, of the answering affidavit of the SIU that we seek to strike out, or portion of it, is in respect of a part of paragraph 21 of the answering affidavit. And the words that are offensive that we seek to strike out are those quoted, inverted comma, that sanity will prevail. Those inverted comma. And we seek the striking out on the grounds that it is defamatory, it's unfounded and irrelevant. And again, it will prejudice the 12th respondent if it remains, as the content is designed to, again, color the tribunal's mind on that allegation and influence it in the determination of 12th respondent's application. The next aspect that we complain about and seek to be struck out is in respect of paragraph 26.3 of the answering affidavit. And we seek it to be struck out on the grounds that it constitutes argument. which is not admissible in affidavits in motion proceedings. And the 12th respondent's prejudice is that if it's not struck out, he cannot respond thereto in terms of an affidavit, because then he will also be committing a wrong by introducing argument, and it should not then stand, because that is destined to influence the tribunal in its decision. My lady, and I apologize for this because of the lateness of these papers having been exchanged, but my lady, I will refer her lady very succinctly to, I think it's 4 cases or 3 cases that are on point and settled in law. Firstly, in regard to defamatory material not being included in affidavits and to be struck out, I respectfully refer you to, it's a constitutional court judgment, and specifically directly on the point at paragraph 28 of that judgment. My lady, in regard to authority for irrelevant material, I refer you respectfully again to the Helen Suzman case, but additionally to the following 2 authorities: Swiss Borough, Diamond.
Sorry, Mr. Ndupo, which paragraph deals with irrelevant material in the Helen Suzman judgment?
My lady, Helen Suzman at paragraph 28 kind of summarizes our law on all of these.
Okay, so it also deals, you are referring me to the same paragraph.
Yes, it's crisply stated. So in regard to irrelevant material, the Helen Suzman Foundation case has cited. In addition, the case of Swiss Borough, Diamond Mines Pty Limited versus the government of the Republic of South Africa. My lady, it's reported 1999, volume 2, SA 279, Transvaal, and particularly at 337, page 337, marginal letter B. My lady, I may alert you that when my ladyship has regard to that, my lady, I will ask that you read just beyond the italicized section of that paragraph in the next 2 lines that follow as well. It's an ordinary print and it may be missed. But my lady, the entire paragraph B is relevant in support. My lady, the next case is VATZ, VAATZ, versus Law Society of Namibia.
VWA.
Sorry, my lady, VAA.
Yeah.
TZ. Yeah. Versus Law Society of Namibia. It's reported 1991, volume 3, SA 563. It's a Namibian judgment at page 566, marginal letter D, specifically deals with authority. My lady, I may also record that VATS is referred to in Swiss Borough Diamonds. My lady, then thirdly, in regard to the attack on credibility, I respectfully refer her ladyship to the matter of Jones, Jones versus...
sorry, I lost you. Sorry, Mr. Nupo, I lost you while you were still giving me the citation and what? Please repeat the year. What year is that judgment reported?
1991.
1991. And then which paragraph are you referring me to?
My lady, specifically at page 566, paragraph D.
Okay, thank you. I've got it.
And my lady, I may record that VATS is referred to in the Swiss Borough Diamond Mines case. My lady, I then want to move on to authority in regard to attack on credibility. And I respectfully refer you to the case of Jones, Jones, versus John, John, next word, Bar, BARR, and Company, PTY Limited. My lady, that's reported 1967, volume 3, SA, at page 292. It's a Witwatersrand judgment, and specifically at page 296, marginal letter C. My lady, we'll therefore ask that
So the credibility point, you raise it in relation to the averment that sanity will prevail.
Correct. My lady will ask that my lady grants the application to strike out with costs. My lady, unless you want to hear me any further on the strikeout application, I have nothing further to submit at this stage on that point.
I'd like to hear Mr. Mgochana.
Thank you, my lady.
May it please the court, my lady. I will be very brief. Can you hear me, my lady? It seems that I've lost your ladyship.
Mr. President, a minute to allow the judge to connect.
Mr. Mgochana, would you please commence? Start from the beginning.
May it please the court, my lady. I will not be that long for obvious reasons. My lady, as far as paragraph 14 is concerned, the averments are mentioned for the simple reason that indeed the SIU believed that it had communicated to the 12th respondent that they no longer will be seeking the relief against the 12th respondent. And as such, the application was unwarranted. Regarding paragraph 16, 17, and 14, your ladyship, those paragraphs, they recite what has been transpiring, what had transpired between the parties until the stage of the filing of the answering affidavit. Your ladyship would have noted that in the answering affidavit, a relief was asked wherein a condonation for the late of filing of the answering affidavit was sought. The SIU could not then not articulate the exchanges between the parties, whereas it also seeks a condonation. I submit, my lady, that evidence or information was necessary.
I just want to understand your submission. So you're saying, yes, these paragraphs deal with exchanges between the parties, but the SIU made reference to that discussion because it needed, it supports its condonation application. It supports its condonation application.
Yes,
is that what you?
Indeed, in a nutshell, that's what the SIU says. Regarding a duplication of annex charge, my lady, I submit that there is no prejudice in that regard. Paragraph 21, sanity will prevail, my lady, means parties will reach each other, because all along the SIU has been saying, we are not proceeding against your client. And your ladyship, you should read this in light of the fact that this is something that was already communicated to the other 14 respondents. So the SIU found it odd that 14 other respondents understood that they are withdrawing the SIU is withdrawing the case against them, but only this particular respondent insisted, because it correctly believed that it had well communicated that it's withdrawing its case against the 12th respondent. Regarding paragraph 26, my lady.
Mr. I just want to ask you, is that the appropriate way of making reference to a colleague's conduct?
A colleague's conduct?
Yes. When whoever drafted the answering affidavit says sanity will prevail, whose conduct are they referring to? Is that an appropriate way of making reference to the conduct of a party or a colleague?
My lady, I'm not sure if that paragraph is directed to an attorney other than to a 12th respondent, because
so it's directed to the 12 respondents, a party.
Yes, my lady, not to a colleague, because
is it an appropriate way of
it may have been
party in legal proceedings?
It may have been a strong word to use, other than maybe to say the parties will find a common ground. But there was no intent to cause damage or to defame the 12th respondent, as the argument from my lady friend is made. My lady, if I may, just a second.
When you say a wrong word was used, so does it fall to be struck out? It shouldn't remain. If it shouldn't have been used, it shouldn't remain.
Leave that part to your ladyship. My lady, if you may, just for a second, I also want to just read a paragraph that, to just have sight of a paragraph before I address your ladyship, just to recap on a paragraph. If you may just bear with me for a second. My apologies, my lady, if I may move to paragraph 26. My lady, in affidavits, it is known and tried that parties make is contained of facts and arguments. There's nothing wrong with arguments in affidavits, other than what is not allowed is to cite case laws. But to put an argument such as submissions, there's absolutely nothing wrong with that. My lady,
by that submission, Mr. Mlechana.
I beg yours, my lady.
I'm very shocked by that submission.
My lady,
long in heads of argument, Mr. Mlechana. In affidavits, you deal with factual averments.
It was bolstering the factual averments, my lady, those submissions. Then, in conclusion, without wasting any further time, my lady, I'll just refer to only one case, for the simple reason that I did not have enough time to prepare and had more case law in as far as responding to the application to strike out is concerned. The judgment of Geffen, Justice Geffen, and another
G-E, yes,
F-E-N and another
F-E-N
versus David N-O and another
V-E-T, David.
David, yes, V-E-T and another.
Oh, W, is it W-E-T, not V?
W, yes, David. It's 2022, Volume 3, SA 465 by Stridom J. at paragraph 27, he says, a striking out of a defense is a drastic remedy, and accordingly, the court must be appraised of sufficient facts on the basis of which it could exercise its discretion in favor of such an order. By striking out of a defense, and in this case of
the relief sought here, Mr. Mlejana. The
My
court
lady,
respondent is not seeking the striking out of a defense. It is seeking the striking out of specific averments or sentences or even words or an annexure. It's not the whole answering affidavit.
my lady, I would submit in response to that those words are contained in an answering affidavit that its sole purpose was meant to provide a defense to the interrogatory application, why it should not be granted. My lady, other than that, I cannot take it any further.
Thank you. Mr. Newport.
Thank you, my lady. I'll be very brief. There's only one aspect I wish to address, and that is in regard to the response to the attack on paragraph 16 to 18 of the answering affidavit, where my colleague's submission was that the contents of those paragraphs were necessary to explain what is happening so as to seek condemnation. Now, my lady, with respect, it is not necessary to do that. Reference can be made to exchanges and correspondence, and the court is told in an affidavit, I'm not putting up these documents because they are without prejudice, but there's been communication on certain dates, and the content is then not allowed in. So the submission with respect by my colleague doesn't assist him in opposing the striking out of those paragraphs with respect. I have nothing other, my lady, unless her ladyship wants me to deal with something other.
Thank you. Mr. Newport, please, I require the word version of your replying affidavit.
I'll email that forthwith.
It should be, yes, forthwith, please. And Mr. Mgwejana, I also require the word version of the SIU's answering affidavit, please, to be emailed forthwith. And then I also require the draft orders from each party, the draft orders that each party, setting out the terms of the orders that each party contends should be granted in this matter.
Thank you, my lady. My lady, would you require us to also forward your word version of the application to strike out?
Those should be uploaded to case lines as well as email. Pardon? Yes, the draft orders should be uploaded to case lines and emailed to Mpho in Word format, please.
Thank you, my lady.
Mr. Mgwejana?
I have nothing further to say, my lady.
Yes, I'm saying you should also file draft orders that you contend.
We will do so, my lady.
Setting out the orders that you would like this tribunal to grant in both.
We'll do so, my lady.
Thank you. That should be done by 4 p.m. today. Thank you very much for your assistance. We've come to the end of today's proceedings. Judgment is reserved.
As the court pleases.
As the court pleases.